Delivering this week's must-watch workplace storylines, this is Bloomberg Law's Punching In, for those of you listening in Washington and across the globe.
Hey folks, thanks for punching in with us. In our first item today, Paul DeCamp is going to join me to talk about the Trump administration's regulatory agenda. Paul is a former wage and hour administrator at the Department of Labor under the Bush administration. Hey Paul, how are you?
Doing great. How you doing, Hassan?
Doing well. Thank you for joining me. Now, as I said, you headed the Wage and Hour Division, obviously, and the department did announce plans to regulate in that area. They announced a joint employer rule and an overtime rule. I'll get back to the joint employer rule in a second. But can you go over the basics of what the overtime rule actually is and what was proposed here on this agenda?
Sure. So for the overtime regulation that they're talking about issuing in March of this coming year, they're really looking at updating what appears to be the salary level with regard to the executive, administrative, and professional exemptions. The item on the reg agenda may be a little bit broader than that, but I think everybody's expecting that it's going to focus on the salary level for those exemptions.
Right, and that threshold essentially sort of decides who is actually eligible for time and a half overtime pay and who isn't. And what are we?
That's a big part of it.
Right. And I'm actually always able to think through these things better in terms of the numbers, but and I've seen some of these numbers, although they don't come to mind at the moment. So I'll ask you, but can you talk about sort of the numbers as far as the number of people that would be eligible under the Obama proposal versus what we expect out of the Trump administration?
Well, during the litigation over the 2016 final rule, the one that got enjoined, the department's best estimate was that about 4 million to 5 million people over the course of the few years following implementation would be rendered ineligible for the exemption or conversely eligible for overtime if their pay were not increased to the new level. And what that meant was that as of 2016, the expectation was that if the Obama-era rule were to go live, it would immediately affect about 4.2 million people and then another potentially 500,000 to 800,000 people in the coming years. With regard to a lower threshold, if we see a number in the low $30,000 range, I think the expectation is that the number of immediately impacted individuals would be significantly lower. I haven't seen an analysis of exactly what that would be. I think that's part of what the department, I'm sure, is looking at right now, but I would expect it to be substantially less than 4 million. It might be in the range of a few 100,000, but we'll have to see what the economic projections are for that.
Now onto the joint employer issues. I've covered the proposal at the NLRB, the National Labor Relations Board, but the DOL also put out a proposal to regulate in this area. And some debate in the labor community right now has been as whether what they put out is supposed to be interpretive guidance versus an actual regulation. So, Paul, can you first tell us what is the actual difference and why does that matter here?
Sure. Those two different types of guidance have different procedures that are required under the Administrative Procedure Act. For a regulation, which is treated as binding, having the true force of law, the APA requires notice and comment rulemaking, a more formal process. For something that is not as formal, there are interpretations that are treated as not necessarily having the same force of law. You can see courts giving a lot less deference to those things like interpretive bulletins that the department has issued, amicus briefs, the fact sheets, that kind of thing. So that's the difference between the two.
And so for folks who might not be super familiar with this kind of thing, tell us practically on the ground, why does this matter?
It's an interesting question. In a lot of ways, the formal differences between interpretations and regulations are a lot less important now than they used to be, and that's in large part because the Supreme Court and other courts have effectively blurred the distinction between interpretations and regulations. There's a case called Auer against Robbins from 1997, and there are a number of cases since then where the courts have afforded a very high degree of deference, for all intents and purposes, treating interpretations as having the force and effect of law unless they're patently unreasonable, which comes pretty close to the same standard that the courts use for judging regulations. So in reality, the regulated community has to treat interpretations as binding law because the courts are very likely to defer to them.
All right, great. Well, we'll keep an eye on that, and we'll definitely follow it as it plays out. Thanks again for joining us, Paul.
Thanks a lot.
All right, in our second item today, some Supreme Court-related labor and workplace news. The Trump Justice Department is expected to switch its argument in another labor case. The DOJ will more than likely begin arguing that businesses do not violate the law by discriminating against transgender workers. That could come as soon as this week. Now, what's interesting here is we've seen the administration do a total 180 from previous arguments. Those usually came from the Obama administration in a number of cases. There's been a case about purging inactive voters from voter rolls, and the other labor case I mentioned earlier is about mandatory arbitration, where this administration switched sides and began arguing that companies can require workers to go the arbitration route, which is sort of like a mediation or negotiation between the parties, as opposed to being able to sue in court for certain claims in the workplace. What's most interesting in this particular case is essentially one piece of the Trump federal government is disagreeing with another here, right? The Equal Employment Opportunity Commission's position is still that transgender folks are protected by our anti-discrimination laws. But the DOJ, as I said, is almost certain to reverse course here very soon. So we'll keep you up on that. All right, that's it for this week, folks. Thanks for punching in with us for the Labor Desk's Monday Morning Musings. For more coverage, be sure to check out our website where the Punching In column is hosted. That's news.bloomberglaw.com. And of course, you can always follow me on Twitter at Hassan Kanu. See you next week.